We've got a terrific program called Is Your Service Too Quick? Presented by Emily Litzinger. Emily is a partner in the Phillips law firm in the Louisville, Kentucky office. The Phillips law firm is a national law firm representing employers, and they have a significant expertise in the hospitality industry. And as you can see from Emily's bio here, Emily has a special expertise in the restaurant area. As a matter of fact, she is so good at it that she was honored and awarded the Supplier of the Year by the Kentucky Restaurant Association. I can promise you, not many lawyers have received an honor like that, but we're happy to have her. Emily, take it away.
Thank you so much for the introduction. So I'm going to run through some of the top 5 mistakes that I've seen happen in the quick service industry, and we'll take questions throughout. So if you have any questions about something that I say, feel free to pop in. All right, so first up, number 1 is failing to update and follow policies. So I know that Stephen had mentioned, in the pandemic and COVID, all of that stuff is changing quickly. We're still dealing with it. So, all of those safety protocols and all of that changed on a dime, and it's hard to keep up. But besides that, just outside of the pandemic, considering your workplace, I often have clients that are in this fast casual industry that fail to properly update their policies. Or in some cases, they can fail to have the appropriate policies in place in the first place. So the cornerstone is, and the key to this is having a comprehensive employee handbook. And so that handbook should be customized to the state that you're operating in. There could be specific discrimination laws, there could be specific meal and rest break regulations, or paid leave requirements. So it's key that these policies are updated on an annual basis and they're customized for your business. The laws changed often, so making sure that they're up to date is important, and making sure you're in compliance. So I have a lot of clients in this industry that often get some templates, some free templates from various resources. And while that's great because it's a cost saver, it can be somewhat dangerous if you're not aware of the specific requirements in the jurisdiction where you operate. So I always recommend that you reach out to counsel to have your handbook reviewed and making sure you're in compliance in the jurisdiction that you operate. So why do you even have to have policies in the first place? Well, first, in some states that require you have certain policies in place, as well as training. But it's really important for you to avoid employment discrimination claims. So if you have a policy, you have it written in place, here's what the rules are, your managers know what the rules are, your employees know what the rules are, and you consistently enforce the policies across the board, you're going to avoid that implication of discrimination. You're not treating anybody differently, you're enforcing it consistently across the board. It's also really important to have a reporting procedure. So in any good handbook, there should be a way in which an employee can report a concern. So their manager, or escalate it to the owner, or they have some anonymous way to report a concern, various avenues to report a concern, and that there won't be retaliated against for doing so. One that has come up pretty often recently are requests for disability accommodations or FMLA leave, and having a policy in place to your managers, your frontline supervisors are aware of what the process is, and they can spot that and immediately, pass it along to who needs to be dealing with those types of requests. And we do so consistently across the board.
Emily, before you go on to that next slide, there's a whole lot of franchisees out there, right? And franchisors are reluctant to provide policies, particularly around safety and security, because they're fearful of the joint employer concepts, as you know. But then we get these franchisees that use the templates like you just talked about. I don't know the solution, but can you give us a little bit of insight on challenges you've seen there so that the folks in attendance can try to solve that?
I've seen that exact challenge. Honestly, in the last week or so, I've had some franchisees come to me and ask, here's my kind of template freebie, here's this policy, and it's very vague. It's a nice little starter, but I've advised them, like, we need to look, you need to be in compliance and where I am in Kentucky. And here's what the requirements are. We're able to provide them with those resources or customize what they already have in place. But that is definitely a challenge, because a lot of these franchisees might not know that they're not in compliance because they believe that they have this other policy in place that's kind of a generic template policy. So, I would just encourage them to reach out to counsel, to labor employment counsel in the jurisdiction that you operate. A lot of are like Fisher Phillips has we're national practice, so we are able to kind of be that one-stop shop for franchisors or other restaurants that operate in various jurisdictions.
Yeah, and my experience with you guys, just so everybody on the program knows, is that they can do it very reasonably for your franchisees. And it's crucial that these things be customized local, state, and federal. And that's Emily's point, and I think it's a very good one. Very quickly, Emily, before you go to your next slide, I just want to remind everybody that policies and training and the enforcement of those, as Emily pointed out, I just want to emphasize that they go toward creating a culture of compliance. And I have found that's one of the most crucial things you can demonstrate in litigation, is that, to demonstrate your acting with reasonable care that your franchisees are, is that if you have those policies, you are training around them and you are holding people accountable to them. Emily, I'm sure you've seen that in your practice.
Yeah, well. I get that as well. I always tell my clients I want to put them in the best defensible position. So you honestly can't stop some people from filing a lawsuit or a charge or claiming something always. But you can put yourself in the best defensible position, and that's having these policies in place, documenting, the enforcement of the policy. So let's say it's a disciplinary policy that you are documenting it consistently for everybody across the board. So it puts you in the best position that you could say, look, we have been enforcing this for everybody, regardless of their protected status or characteristic.
Yeah, great stuff.
All right, so next up we have improperly using the tip credit. So this is tricky. Anything with tipping tends to be pretty tricky because the regulations and the laws vary from state to state. So again, it's important that you're aware of what's going on in the jurisdiction that you operate and what the laws are. So by way of background, the tip credit can only be used for time spent when engaged in a tipped occupation. So there are some employees that are not that are performing non-tip producing work. Let's say like a delivery driver or somebody in that role. They're spending time, maybe they're cleaning, they're doing various back of house chores. The employer cannot take the tip credit for the time spent doing that. So the Department of Labor, this has recently changed. They reinstated what's called this 80-20 rule, which means an employer loses the ability to take the tip credit on a tipped employee when they're spending more than 20% of their weekly hours performing non-tip producing work, so side work. That would be work that they aren't directly producing tips for. So like you're not directly, taking orders, or you're not directly serving a customer, something off to the side. So that is important. And also part of that is an employer loses the tip credit for a tipped employee who's doing this side work for a continuous 30 minutes that exceeds 30 minutes. So this is even if they're still less than that 20% of the total work for that week. If they're doing something that's a side job or not a tipped work, then you cannot use the tip credit for that time that exceeds 30 minutes. So in my experience, given the complexity of these rules and the unique nature of the quick service restaurant industry, most of my clients have avoided taking the tip credit because it is just an administrative headache. There is such a potential for liability. And oftentimes, and I'll talk about tip pooling, there are special rules that apply when you are tip pooling with front of house and back of house. So most of my clients in this industry have just decided they're not going to do the tip credit. They're going to pay the minimum wage and avoid those sorts of issues. All right, number 3, non-compliance with child labor laws. This one is spiked. It actually spiked for me right before the pandemic, and then recently, probably within the last 6 months, because of the labor shortage. So a lot of fast casual restaurants are struggling, just like every other employer, to keep people employed and in the restaurant. So they've started hiring minors to get enough labor. So there are federal and state laws that are going to cover how many hours a minor can work, what the time frames are. And that varies from time of year. So in the summer, the regulations are different than when school's in session. What kind of job duties they can perform, how often they're taking breaks, and how long their breaks are. To complicate it even further, when you have a 16 and 17-year-old, there are certain rules. And then when you get younger, like with 14 and 15-year-olds, it's even more strict. So what we're seeing a lot is issues where minors are either working too many hours in any given week or day, or past a certain time frame, a certain time of the day, or they're performing hazardous duties. So this could be as simple as, depending on how the restaurant's set up, if you have a fry machine operating that, not in every context is it a hazardous duty. It just kind of depends on the performance of what exactly they're doing. So it gets very fact intensive. I recommend that all managers be trained about what the regulations are in that jurisdiction. So they're going to be the ones that are at the ready. They can see what's happening. They're going to be the ones that are dealing with scheduling, and they're going to be dealing with, they're going to be able to point out what potential issues are. So if they're aware of what the regulations are, that's going to help you avoid any sort of issues.
Emily, if I can, just real quick on that, you guys, Fisher and Phillips sent out a terrific newsletter yesterday that talked about the challenges that the Ukraine situation may drive here in the U.S. And I bring it up now because one of the things they mentioned was the need for people that come over for asylum, et cetera, that come here. They're going to be looking for work. And my feeling is, as you've pointed out, during COVID, a lot of younger people probably went to work earlier than they anticipated to, right? Because their family needed the money, et cetera. And so we're seeing, I think it's great timing to talk about child labor laws. At the same time, I'm hopeful that everybody on the call will be sensitive to the hiring of people from, the Ukraine region that have been displaced and coming over. And I think the immigration aspect, again, training, as you pointed out, to your managers and compliance there. And I think, if I'm not mistaken, I think we'll see many people under the age of 18 trying to work as well. Don't know how quickly this will evolve, but any thoughts about any particular immigration issues? And that might not be your area.
Yeah, it's certainly not necessarily my area, but I think that overall the economic impact will ultimately result, it always impacts the workplace. So we always see this, with COVID, with, the recent labor shortage. It's just, it's a sign of the times for sure. I mean, I definitely think, and your other speaker will be able to elaborate, but this certainly will continue to impact the workforce, and uncertain really how it's going to impact it at this point.
Yeah, and so I think that's exactly right. And then from just a couple of specific perspectives, what are the rules around asylum? People that have come in as asylum seekers, are they the same rules? I think we're going to have to get up to speed on that. But the other thing is that a lot of people may be called away to go in the military, the National Guard, et cetera. And so in terms of training that you mentioned, I'm hopeful that everybody will think about getting up to speed on what those rules and regulations are on dealing with people that are going off to serve our country. Yeah, there's a lot going on here, isn't there?
Yes, yeah. There is.
There is. Sorry to interrupt. Go on to the next one.
All right. So number 4, this kind of dovetails into the policies, but failing to provide harassment training for employees. This seems really basic, but it's often overlooked in the hustle and bustle of the restaurant industry. Training is so important. Having your managers participate in a live training, it can be a virtual, but when you have like a live audience, not one of the computer modules, on an annual or biannual basis is very important. There are some jurisdictions that require this training on a regular basis, but even if you're operating in a jurisdiction that doesn't require it, I can't tell you how much it will save money for you in the long run. So the training should outline what type of behavior, it'll go through your policies, but what type of behavior is prohibited, and how do you report that behavior, and what steps are done to investigate it, and how do you document, and the follow-up, including any sort of discipline that's going to happen, and that you ensure that there's no retaliation for making any sort of complaint of harassment or discrimination. This buys you a little bit of a defense as an employer for you to be able to say that you took the reasonable steps to prevent any sort of harassment or discrimination in the workforce. Obviously, you're going to have to still follow your policies, but it puts you, like I said, in a better defensible position later on down the road. All right, so I kind of touched on this unlawful tip pools. So currently, if an employer takes a tip credit, like I mentioned previously, they can require an employee to contribute to a traditional tip pool, which means those individuals at the front of the house typically, but customarily and regularly receive $30 or more in tips per month. So that's going to be servers, hosts, bartenders, anybody in the front of the house, you can require that. Any sort of mixed tip pool, so back of house or chefs, cooks, dishwashers, and front of house, and previously they were prohibited, but in March of 2021, the Department of Labor issued a final rule that allows for mixed tip pools between the front of house and the back of the house. So that includes people who are not traditionally tipped. The catch is those people, the participants, they all have to be paid the minimum wage. So like I mentioned before, with the tip credit, a lot of my QSR clients are saying, we're just going to pay everybody the full minimum wage, and we're going to have a mixed tip pool because of the structure of the business. It seems to work out a little bit better for that model of the business. What's key about both of these is that supervisors and managers are strictly prohibited from participating in the tip pool. Now, if a supervisor, and Stephen had pointed this out previously, if a supervisor is actually doing the tipped work and they're only getting tipped directly to them, then they can keep the tips. They can even contribute to a tip pool. They just cannot receive any money from a tip pool. And another little catch, if you haven't seen a theme here, every state varies on their regulations. Some even prohibit mandatory tip pools entirely. I'm in Kentucky, and Kentucky has a prohibition on mandatory tip pools. So my clients in Kentucky have to, if they want to have a tip pool, it has to be completely voluntary. And in those circumstances, we typically have an arrangement that's laid out based on what the employees have decided, and we make sure that they, receive this notice and that they sign off that they understand it's voluntary in nature, and that kind of covers the employers. So they're not otherwise, there's not the argument that you're coercing them into a mandatory tip pool. So that is all I've got. If you've got any more questions for me, or I could pass the baton back to Stephen.
I've got a couple of questions. I don't see any in the queue, but the harassment discussion, I think, is right on target because we're still seeing that type of litigation. The research shows that the restaurant industry, along with the hotel industry, has some of the highest incidences of sexual harassment, right? And other types of harassment. And of course, given the divisiveness, Emily, that's going on in the country, you're probably seeing more of that. But here's my question. Are you seeing more of third-party harassment cases? You know, are customers harassing our employees or vendors harassing our employees? I'm curious about what you're seeing.
Yeah, I would say the thing that I've seen because of COVID is a lot of patrons that are upset about whatever safety protocols in place. If there's like a masking requirement or a vaccine requirement or something of that nature. So it's not necessarily, you know, your traditional harassment because sexual harassment or religious discrimination or anything like that. That's what's been on the most prevalent in this industry. I'm just dealing with patrons that are difficult and trying to do so in a diplomatic way while also protecting your employees and your business reputation. So that's been a challenge. You know, I think there are always in this industry that there's always that concern because of just the nature of it, and that you're dealing with customers, you're dealing with vendors, you're dealing with third parties often, just because of the business. I think that's all. It's for me, it's been pretty consistent in that regard. I haven't seen any major changes, but the COVID protocol thing, it's just really hard to run a business, especially in the hospitality industry.
Well, especially in training your people to de-escalate is one of the greatest challenges we have, right? Back to the third-party harassment real quick. I just want everybody on to know that, and Emily, I hope you agree, and if you don't, please say so, but I feel like in any of our harassment policies where we express zero tolerance, we need to include third-party harassment in that prohibition. Is that fair?
Yes, and you have an obligation to protect your employees from that sort of harassing environment. So if you're an employer and you know that customer X is harassing your server and they've brought it to your attention and you're aware of it and you don't do anything about it, you could be on the hook. You as an employer could be on the hook because you're aware of that.
Yeah, I think that's exactly right. And I had the privilege of working with one of your partners, Andrea Ryan, to create a video, a short 20-minute video around third-party harassment. It's on our blog if anybody is interested in taking a look at that. It's really meant for in-house counsel and upper management. It's not meant as a training device for your employees, but if you're interested. Emily, one other question.
Sure.
In the queue, and that, you know, Grace Yang with Gray Robinson is going to do a talk on ghost kitchens here in a little bit. But in regard to ghost kitchens, are there tipping issues that we need to think about, or that have perhaps come up in your thinking about this? For instance, I'm wondering can we do a mixed tip pool with the drivers and the back of the house? It sounds like perhaps that's allowable these days.
Yeah. As long as you're not doing a tip credit, if everyone's getting the minimum wage, then the regulations are vastly different. So when you're using the tip credit, that's where all of these kind of don't use these participants, and it has to be, you know, the mandatory part of it. So when you're putting together, I mean, and honestly, because I'm so used to working in a jurisdiction that requires it to be voluntary, oftentimes I just say, hey, why don't you set up this, work with your employees to set up this voluntary tip pool, and then people want to participate, they participate. Most often people participate because everyone else is participating. So in those circumstances, it's kind of, you're removing a bit of that potential liability.
Okay, very good. So I'm going to put you on the spot here before I let you go.
Oh, great.
Yeah, I know you like this. What's the most frequent challenge you run into with your restaurant clients?
I think honestly, it's not having policies in place. Like a lot of times they don't have anything in place and they're not really sure what's going to happen until a problem occurs. And then they're like backtracking, trying to figure it out. And maybe they're like halfway through it, say they get a complaint and they're trying to deal with it. They don't really know how to deal with it because they don't have any training or policies in place, and they're doing the best they can. And they kind of makes it more challenging for me to defend them, because it just makes it more costly, because there's just more, it's more of a tangled mess.
It is. That's a good way to put it. Very good way to put it. Emily, as always, thank you very much for joining us today.
Thank you.